The acceptance of appointment. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover a form called the acceptance of appointment. This form is SCAO form, State Court Administrative Order form, PC 571. You can see the number of the form at the bottom left corner of any of the SCAO forms. The PC stands for Probate Court, and 571 is simply the number assigned to it. The acceptance of appointment form is a versatile form. It's used in a variety of different types of files: guardianship, conservatorship, probate estates, trust administrations. So this form is guided or is created by various statutes and court rules. Now, if you look at the floating arrow at the bottom right of the screen, you'll see the various statutes and court rules that give rise to this particular document. Let's examine each of those statutes and court rules that are applicable. MCL 700.3601 is the general statute that talks about before receiving a letter of authority in a deceased probate estate. So this is a probate administration. The personal representative that has been nominated or appointed by the court will qualify by filing of an acceptance of appointment. This is the document that's used to do so. In addition, the personal representative can exclude from the scope of their role to administer certain assets. So, for example, if there are assets that are part of the deceased estate that are, for example, very risky to be administering, you can exclude the scope of your role as it relates to those particular assets. Now, the statute 700.3601 is quite extensive. I've only scratched the surface of it. The next statute referenced is MCL 700.3602, and this is a common theme with this acceptance of appointment document. When you, as the fiduciary that has been nominated, sign it and file it with the court, and then obtain your letters of authority, whether it's in a deceased estate, guardianship, or conservatorship, you are then consenting to the jurisdiction of the court. So imagine you've been appointed maybe in a will, or you've been appointed or nominated through a proceeding. This document says, I accept. I am filing the document to accept my appointment. I will take on the role as fiduciary. I'm obligated to follow all of the statutes and court rules that are related to my duties and responsibilities, and I consent to the jurisdiction of the probate court involving affairs that relate to the estate. So 700.3602 addresses that issue. The next three statutes relate to guardianship proceedings. These are statutes MCL 700.5214, MCL 700.5301, and MCL 700.5307. Again, similarly, if you're nominated as the guardian, whether it be in a will or through a probate court proceeding, you sign this document before you get your letters of guardianship, and you consent to the jurisdiction of the probate court. Statute MCL 700.5412 is a similar statute, but it relates to conservatorship. Remember, guardianship for care, conservatorship for finances. So the conservator is accepting the appointment, has a right to exclude assets from the representation or their responsibility, and consents to the court's jurisdiction. The statute MCL 700.7202 relates to revocable trusts or trust administrations in which it's being supervised by the court. Again, the acceptance of appointment confirms the appointment, says that they agree to consent to the jurisdiction of the court as it relates also to the court rule that's mentioned here, MCR 5.501. Again, in trust proceedings that are under the court's jurisdiction, that is the process for the appointment. Now remember, there could be other requirements outside in each of those various estates for the qualification of a personal representative, a guardian, conservator, or so on. So the court may require other things besides this document. For example, the most common additional document that's required before you can qualify and obtain your letters of guardianship, conservatorship, or personal representative is to file a surety bond or a nominal personal bond. So often that is an additional requirement to the qualification as fiduciary. If you have questions about that process, I've done a video on that form, the bond of fiduciary form, that is another SCAO form, and how to go through the process of qualifying for a bond and why a bond is even required when you're serving in that fiduciary role. So let's work our way through this particular court document. Top left corner is the county in which the probate is pending. Top right corner is the case number, the file number that's been assigned by the court. At the top, you identify the estate of. This could be a deceased estate. This could be a guardianship or conservatorship or a trust. That's simply the title that's reflected there. This next section identifies who the person is, the type of fiduciary as referenced in that blank line. So are you a guardian, conservator, deceased estate? Now, sometimes you're appointed in multiple capacities. You're wearing two hats. You may be appointed as guardian and conservator. In that case, you'd be filling out a form in each of those two different file numbers. So you have to do this twice. And in each one, you identify what fiduciary role you're serving in for that particular case number. So it identifies that you have accepted the appointment, and as I mentioned in all those statutes earlier, you are consenting and submitting to the personal jurisdiction of the court, and you're agreeing to perform all of the legal responsibilities on behalf of the estate. So when you sign this document and file it and agree to serve as a fiduciary in any of those estates, recognize this is a really large responsibility. And you should do so with a deep understanding of the statutes and court rules and the rights and responsibilities and duties you have in that fiduciary capacity. Because breaching or not performing your duties can put yourself in tremendous jeopardy, could subject yourself to liability. So it's really important that you're guided with a professional, an attorney, and that you understand what it means to serve in that fiduciary capacity. When you sign this, understand that this is a very large, important responsibility, and you are accepting that appointment, that you have understood all of the rights and responsibilities as delineated in the statutes and court rule. Often when people make mistakes, they say, well, I didn't know. Well, when you accept your appointment, you are presumed to understand your duties, and your ignorance of those responsibilities is no excuse for the performance correctly and to carry out your fiduciary responsibilities on behalf of those various estates. Subsection 3 is a rarely used area, and it relates to removing from the scope of the responsibilities a certain asset or business entity. It is used in limited circumstances when the personal representative doesn't want to take on a particular aspect of the administration because of the risks associated with it. Again, to dig into that particular issue and the issues involving hazardous substances, very risky businesses and things like that, contact my office. We're happy to provide you some additional guidance about that particular aspect of the acceptance of appointment. As you work further down that document, you'll see that there's a date area, signature of the personal representative, guardian, or conservator with an address, and it requires you to identify your date of birth. In addition, the attorney, if there's one involved in the file, would be referenced on the left side. There's a use note that talks about if you are filing this in the family division of the circuit court, you're supposed to enter that case number also on the form. And it's understand that you fill out this form and then it gets filed with the probate court, and that triggers the issuance of those letters. This is the letters that provide evidence of your appointment in those fiduciary roles. There's a filing fee, not with the filing of the acceptance of appointment, but rather the issuance of the letters, and each letter is a separate filing fee. So when you've done this, you are now appointed on behalf of the estate. You get to carry out your responsibilities, and this is just the beginning. The beginning of this journey through the administration process, whether it be a deceased estate, guardianship, conservatorship, or a trust estate. At the Probate Pro, we're passionate about probate-related issues. If you have questions about the acceptance of appointment or any probate or trust-related matter, visit us at theprobatepro.com or call us at 1-833-PROBATE.